Hi, I'm Ben Holden, Director of the Reynolds National Center for the Courts and Media. You know, we're all blessed to live in a wired culture that was built on the sharing of ideas and innovations. Search engines, document viewers, social networking platforms, open source software programs, amazingly useful works of creativity are made available free of charge to anyone with internet access. At the same time, our legal system recognizes that people who invest in original works of creativity, movies and songs, books, even maps and wallpaper designs, need to have some assurance that their work won't be repackaged and resold by someone else the day it hits the market. That's the foundational principle behind the Copyright Act, and that principle still applies today, even when valuable photographs and drawings can be cut and pasted in the blink of an eye. Copyright law, though, is not absolute, and our courts have recognized that culture develops as one generation takes inspiration from the one before. That's the reason the Copyright Act recognizes a defense called fair use. But fair use is as much an art as a science. There are no magic formulas, just judgment calls. Learning the law of copyright and the exceptions and safe harbors will help you make an educated judgment call to stay on the right side of the law. Here to tell us more about copyright law and fair use is Frank Lamonte, Executive Director of the Student Press Law Center.
Let's say you take a photo that's one of those once-in-a-lifetime career photos. You've got the winning touchdown catch in the conference championship football game. Beautiful action shot, goes up on the front page of your student newspaper, goes on the website of the student newspaper. Next day, you start getting these text messages from your buddies all over the campus. They're telling you, dude, you are famous. And because it's a text message, it's just the U and the R, right? Dude, you are famous because your photo is showing up all over the internet, and you're getting these links from your friends. Check this out, check that out, look here, look there. So you click on one of those links, and it takes you to the website of a magazine that is reviewing the best sports action photos of the week, and your photo is one of them. Well, you click on the next one. That takes you to Ralph's Sporting Goods, and Ralph's Sporting Goods has your picture as part of the front page of that newspaper, reprinted on a t-shirt for sale. Now you're getting kind of steamed, right? You click on that third link, and that takes you to the Facebook page of somebody that you don't even know. And that person has taken your photograph and has cropped it down little bitty, just the receiver's hands catching the ball, and he's using that as his icon for his Facebook identity. Well, now you're pretty mad. All these people are taking your stuff, they never asked you for it, they never paid you for it, and they never even gave you any credit. And so you go dash off a letter and you print it out on the newsroom printer. And when you go to the printer to get that letter, there's your editor sitting there with the letter in his hands, because editors have really easy jobs and they have nothing to do but read other people's letters, okay? So he's sitting there reading the letter and he says, wait a second, Scoop. He calls everybody Scoop. It's very annoying. And he says, wait a second, Scoop. That's not your photo. You took that photo for the newspaper, and if anybody's going to enforce the copyright, it's going to be me. So, where are your rights here? That's what we're going to talk about in the next few minutes. We're going to talk about the law of copyright, because the law of copyright will dictate how protected that photo is and what other people can and can't legally do with it. Let's start out with the basics. Copyright law is nothing but a federal statute, the Copyright Act, which says that people have a right to control the way that their original creative works are used. And remember, it has to be original and it has to be creative. You've got a bundle of federally protected rights that include not only selling that image, not only selling that work, but also controlling how other people adapt it or distribute it or create other works that are based on that original piece of creativity. Let's go ahead and let's admit straight up, this is a hard concept for people to get their heads wrapped around in the internet age, when the ethic of the internet is share and share alike, no harm, no foul, what's mine is yours, right? That's the culture that we live in today. I can't tell you, that if you reuse one photograph that you're going to get busted and go to the copyright penitentiary. I can't. Likelihood is it won't happen. But you want to learn to turn square corners for a couple of reasons. First of all, One of these days, you'll be out at a professional media outlet where you're playing for keeps, the stakes are high, the money is big, and you may find yourself the target of a copyright infringement suit. More importantly, many of you are going to go out there and are going to be creating valuable pieces of creative property. Maybe you are already like that touchdown picture. You want to be the one that can control how that is used. You want to be the one that can profit if it is resold. Copyright protects your rights as the creator and your investment in the work that you create. First things first. Let's say, instead of that touchdown photo, all you have is the idea for a photo. You've got this great concept for setting up a feature photo, magazine cover quality photo. You're out at the bar, talking to your buddies, describe this photo down to the last detail, just exactly how you would do it. And then a couple of days later, you pick up the campus magazine, and there's your concept, down to the last detail. The caption, the header, the framing, everything is exactly as you described it. Can you do anything about this? The answer is yes. You can get better friends. But you can't bring a copyright infringement case because copyright doesn't protect the idea. It doesn't protect the concept. It only protects it once it is frozen in a tangible form. You got to snap the shutter. You got to burn the DVD. You got to save the document. Something that freezes the information in a tangible form, that creates a copyright protectable work. This is important because if you're working for the campus newspaper, there may come a day when you're driving down the road listening to the campus radio station and there's somebody reading what sounds a lot like the information that you just reported in that morning's newspaper. And you may say to yourself, hey, wait a second, that's my information. Where do they get off sharing my information with people without paying me or crediting me or asking my permission? And the answer is it may be your story, but it's not your information. Copyright protects the manner of presentation. It protects the way you phrased the article. It doesn't protect the underlying information. So, if another media outlet does no more than summarize what you wrote, putting the work into their own words, then they're not violating the Copyright Act. Does anybody have any questions about that? Yes, go ahead.
All right, so even if it isn't a violation of copyright, let's say somebody just rereads your story on air and doesn't give you credit for it. Isn't that still plagiarism?
It certainly can be. It certainly can be. This is where people get mixed up in their minds about plagiarism and copyright, and they're two very different things. Plagiarism is about credit. Copyright is about ownership. Let's say you're in an advanced English lit class, and you decide you're crunched for deadline, pressed for time, and you're just going to take Shakespeare's The Tempest and put your own name on it and turn it in as your assignment. It's a very advanced English lit class, and you're just going to turn this in as your own piece of work, okay? Have you violated copyright? No, right? Because The Tempest was written in England 400 years ago. We had no Copyright Act then. You certainly haven't violated copyright. But have you plagiarized? Sure, and pretty stupidly too, right? Because plagiarism is about credit and copyright is about ownership and about consent. Don't fall into that trap. If your website puts a photograph from Newsweek magazine on the website saying courtesy of Newsweek.com and you haven't paid for it and you haven't gotten consent, that credit line helps you not at all in copyright law. It's not plagiarism because you didn't represent it as your own photograph, but it can certainly be copyright infringement. In fact, under copyright law, that credit line not only doesn't help you, it's a signed confession. It's a signed confession to where you got it from. Anybody have any questions? Yes, go ahead.
If people put something on the web and don't do anything to protect it, haven't they put it in the public domain?
There is a real pervasive myth about the public domain. The public domain is this mythical fairyland where photos and songs fly free. But in fact, the public domain is really much more limited than that. There is very little that's truly in the public domain that you as a student journalist would have any practical interest in using. Copyright lasts a long, long time. Something that you create today will be under federal copyright protection for at least 70 years and probably more. And so there's almost nothing that has aged out of copyright protection that you would care to publish in a newspaper. Maybe some old stuff before 1923, but that's not what you're looking for on the internet. And remember, the copyright applies to the version of the work that you are looking at, right? So that Scott Joplin's song, The Make-Believe Rag, has aged out of copyright. The song has, but not a recording that's made today. A person who makes an audio recording playing the piano today is going to have a lifetime's worth of copyright protection for their recording of the song. Anybody have another question? Yeah, go ahead.
What does it mean if the copyright symbol is not on a picture or a story? Does that mean it's not copyright?
It used to be the law. There was a time when something had to display the copyright symbol in order for it to be legally protected. Congress amended the Copyright Act back in the 80s, and that's no longer true. So you can't take any comfort in not seeing the C in a circle next to the work that you're trying to borrow from. It's a good precaution if you're a person who's invested a lot of creative energy and expense in your work. It's good precaution to register it with the Library of Congress and get that copyright protection and display that C in a circle. But legally, it is absolutely not necessary for a work to be protected by copyright. I do want to give you a couple of hints and a couple of leads about places where, especially for online publishing, you can find material that's not protected by copyright that you're able to help yourself to and use. And the big one, the first one to be aware of, is the .gov domains. Federal government works created by federal employees in the course of their employment are not protected by copyright from the day they are born. And so if you need a photograph of the president, the first lady, the White House dog, some head of state, some foreign leader, go to the White House website. Try that one first, because they have an official photographer whose job it is to generate images and now even video clips. And those are all copyright free. Those are yours for the taking. Same with bills filed in Congress, Supreme Court opinions, any material generated by federal employees, and notice I said federal, not state, federal employees, is copyright free, and you're free to use it without paying anybody and without asking permission. The other resource, a growing resource to be aware of, is material that's protected under the alternative to copyright called Creative Commons. Creative Commons is that CC in a circle symbol that many of us have gotten accustomed to seeing. Creative Commons is an alternative to copyright. It is a way that people who create photos or videos or songs can share those by voluntarily forsaking some of their copyright protection. Now, it does not mean that the person is giving away ownership. Creative Commons is a license, and what that license means, and you have to read the fine print, they're not all the same. What that license typically means is that if you are an educational or a journalistic or a nonprofit user and you in the student media qualify, that you may freely reuse that Creative Commons protected work without having to get consent if you credit it appropriately, if you credit it as the creator asks. That's yours to use. Look for those. You can use search engine, advanced search features to find those images, or you can use one of the increasing number of photo sharing sites that are out there where people have voluntarily placed their images for public reuse. So let's say none of those options works. I can't find the government photo, I can't find the Creative Commons photo, I've just got to use something that I've found in an image search online. Am I completely out of luck? Well, for starters, remember you can always get consent. Consent is chicken soup for the lawyer's soul. It heals everything. Consent is the gold standard. If you get consent, you're of course not violating copyright. Depending on what you're using, informal consent may be just fine. If you want to use something that doesn't have a huge amount of economic value or investment in it, say a photo on Facebook, maybe an email is enough, maybe a phone call is enough. You want to reuse something that's really, really valuable, get that consent in writing and save it for your own protection. You must make sure, remember, that you're getting consent from the person that has the legal authority to give the consent. For example, if it's a photograph with me in it, unless I held the camera up to myself, I'm not the owner of the rights. The owner of the rights is the creator of the photo, not the subject of the photo. That brings us to issues of ownership. Okay? The normal rule under copyright law is that the creator of the work owns the copyright to the work. There is an exception known as a work made for hire. Work made for hire is work that is done in the course of salaried employment. And work that is done in the course of salaried employment, a story that you write, a photo that you take, that belongs to the employer, and it's the employer who can enforce the copyright. Notice that I said salaried employment. If you're just doing piecework, if you're just doing a one-off photo for the newspaper and they pay you $15 for that shot at the football game, that's not salaried employment. What that implies, that's more like a freelancer arrangement. What you've given the newspaper as the photographer there is not ownership of the photo. You've given them a license to the photo. You've given them limited consent to use it in a foreseeable way, but not your full ownership rights. The newspaper can use that photo in the next edition, they can use it in the week in review, they can use it in the year in review, they can use it in all the foreseeable ways on their website, in their magazine, all of the foreseeable ways that would grow out of that understanding. If they start to treat the photo like they own it, right? If they put it on a t-shirt, put it on a coffee mug, put it on a calendar and start selling it for a profit, then that might exceed the terms of that license, and you, not they, may be entitled to the proceeds. Consent is always the best starting point. Consent from the rights holder is always the best course. But what if you can't get consent? What if you maybe can't even find the person who's the rightful owner? Are you completely out of luck? The answer is no. There is a recognized defense to copyright infringement called fair use. And fair use, at times, will entitle you to reuse somebody else's material without paying for it, without getting consent, if you can satisfy the fair use factors. And we're going to run through those factors now. And this is the discussion you should be having in your newsroom when you're thinking about borrowing that picture off of the internet is, can I satisfy the fair use factors? Is what I am doing defensible under the federal copyright law? A person who is accused of copyright infringement can defend themselves by demonstrating that what they have done is a fair use. And you will hear people who don't have a complete understanding of the law say something like, well, it's always a fair use if I use this celebrity photo because I'm driving up interest in the celebrity. I'm making people want to see their movies. I'm making people want to buy their CDs. Don't listen to those people. That's not the law. Here is the law. The law is you got to run through that four-factor analysis, and that starts with number one, who are you? Because not all users and not all uses are created equal. As a journalist, as a nonprofit, you are going to get a heightened level of protection that would not be true if you were reselling that material to make a buck. So that if you are going to use, let's say, a video clip from Martin Luther King's I Have a Dream speech, and you're using it in a news documentary about the civil rights movement, you've got an excellent fair use argument. That would not be the case if that very same video clip showed up in a car commercial. In a car commercial, that's not going to be a fair use. In your news documentary, that brief little clip probably is. For your purposes as a journalist, one of the classic textbook fair uses is to review or critique the material, and we've all seen this. Something like one of those television movie review shows where they'll show you a clip from the movie that they are reviewing. Remember that if you're trying to take advantage of that exception, that you have to actually be reviewing what you are borrowing from. It's not enough that you want to write about the subject of the photo. You want to be writing about the photo. Here's what I mean by that. Let's say you're doing a story about the famous Sports Illustrated cover jinx, where people who get on the cover of that magazine perform badly, right? And so there is a photo on the Sports Illustrated cover of the quarterback of the Notre Dame football team. Well, in writing about the magazine cover jinx, you get to use the magazine cover. That's a fair use. It's necessary to tell your story. But if you're just writing about the Notre Dame football game, using that same photo is probably not a fair use, because you're not writing about the magazine, you're writing about Notre Dame. You're not writing about the photo, you're writing about what's in it. That's the difference. Second factor, question number 2. What is it that you're trying to reuse? Copyright law is all about safeguarding people's investment in their creative works. Bigger the investment, better the copyright protection. Not all works are created equal. That little snapshot that you see of my cat sleeping in a window on Facebook is not going to get the same difference under copyright law as James Cameron's Avatar, right? One has an enormous amount of creative investment. One was taken in 1 second with no particular creative investment and no particular plans to resell it or profit or make money off of it. That brings us to question 3. How much are you using? Copyright law recognizes that it is more likely to be a fair use if you use only as much as you need to make your point and no more. Okay? Think about it like this. Think about last time you went to the supermarket, and there's that lady at the end of the aisle with a little table set up, and she's trying to sell the new flavor of Gatorade, and she's got those little shot glass sample sizes of the Gatorade, right? You can have a taste, that's okay. She won't give you the whole 64-ounce jug, right? Because that fully satisfies your Gatorade needs. At that point, you're not interested in buying it anymore because she gave you too much. You can always whet somebody's appetite. You can't quench their thirst. That's the difference. This is where a lot of people get tripped up by their own logic. They'll say to themselves, look, I'm just one little bitty blog here. How is it possible this blog that my mom and my 2 best friends read could undermine the value of Taylor Swift's music video if I embed it on my website? The answer is the law doesn't care about little old you. It cares about you and you and you and you. And if everyone starts helping themselves to a free copy of Taylor Swift's music video, pretty soon we have undermined the market for that music video, and Taylor Swift is shopping in the discount bin and working the night shift at the Waffle House because nobody wants to buy her stuff anymore. That leads us into the 4th and the most important factor. What is the impact of your use on the market for the original? Is your use a substitute for someone buying or viewing the original? Because if it is, if you're taking sales out of the pocket of the creator, chances are you're not making a fair use. This is why, if you're reviewing the Lady Gaga CD on your website and you want to embed a player that plays 20 seconds, 25 seconds of one song as a sample, probably okay. But you never want to give somebody start to finish an entire track that they can download and save and replay. Why? Because every track is a saleable unit. Every track that you give to me is a track I won't buy from Lady Gaga's music company. That's too much. That's not a fair use anymore. Now you're undermining the market for the original. You'll hear people say, that it's always okay to play 30 seconds of a song, it's always okay to use 10% of a magazine, and be careful about that, be cautious about that, because the Copyright Act itself contains no numbers and no percentages. There's no formulaic safe harbor. The fact of the matter is, it's possible to infringe copyright, even by using a very small amount of the original, if what you republish is the heart and soul of the work, the thing that gives the work its resale value. If you undermine that resale value by giving me for free the thing that gives the original its value, you probably aren't making a fair use anymore. One more principle under fair use to keep in mind. There's a doctrine recognized by the Supreme Court called the transformative use, and it has nothing to do with Transformers. What it means is the more of your own creativity that you can add to something, the more that you can make that photo, that drawing, that cartoon, make it your own so that its own mother wouldn't recognize it anymore, the more likely you are to be making a fair use. This is why people can get away with parodying a song, for instance, or parodying a music video, because they've added so much of their own creativity. They're using that in a way that makes a brand new point, in a way that is much different from the way that the original creator designed it. Try, if you're going to try to make a fair use, to add some element of your own creativity. Try to change it up from the original, and the more you invest in it, the better your fair use argument. That's the law. Now let's talk about the practical realities. Because the practical realities are that not all users are equally motivated to come after you to enforce their copyright. If you're going to engage in some strategic borrowing, always be conscious of who you're borrowing from, because some users are much, much more likely to enforce their copyright than others. The people who are going to be the most ardently defensive of their copyright are people who are in the business of selling stuff like that to people like you. If my business model, if my livelihood depends on selling that photo to you and you take it for free, I'm your nightmare copyright plaintiff. At that point, I've got to come after you, because if I don't, my business is dead, right? So if you go online and you see something that looks like a posed, professionally taken studio photograph, maybe a wedding shot or a graduation shot, you want to treat that like it's radioactive. You want to leave that alone. Why? Because the professional studio photographer owns the rights to that shot, and that person will be more than happy to sell you a duplicate, but they do not want you taking it for free. Same principle goes for a wire service. Look out for content from the Associated Press or Reuters or Agence France Presse or any of those wire services, because why? Because their business depends on getting people in the media to purchase their creative work. And if they start letting it go out there for free, they're out of business. Okay, let's go back to where we started. Let's go back to that game-winning touchdown catch and your photograph, and look at the way people online were reusing it. Let's think about whether, using those 4 fair use factors, any of those reusers was making a defensible fair use. If you're watching this as part of a class, this would be a good time to turn off DVD, turn off video, and have a discussion amongst yourselves. Okay, for everybody else, let's start with the easy one. We all know, right, that the guy who took your photograph and made it into a t-shirt that he is selling for profit is not making a fair use. There is no way that a court is going to say that you get to take other people's creative property and turn them into a profit-making product without consent or without paying. Now, the question is, who gets to enforce the copyright? Because remember, we said this is the entire front page of your newspaper. It may very well be that the person who gets to enforce the copyright is not you. If somebody reprints the entire publication, now we have what copyright calls a collective work. And the publisher may be the one who holds the right to enforce the copyright because the publisher holds the right in the collective work. That's the easy one. Now let's talk about the website that reviewed your photo as part of the 10 best sports photos of the week. Remember we said reviews and critiques are a classic fair use. So this starts to sound a little more defensible, right? Look at the factors. Think about how they would apply. Think about the doctrine of transformative use. If that website has changed up the photo from the original, if they've shrunk it, cropped it, made it so that it's not so easy for somebody to just make an exact duplicate of your 6-column wide photograph and download it and print it and use it as their own, if they've added any of their own original content, especially as part of a review, critique, or commentary, now it's starting to sound like that's a defensible fair use. Lastly, let's turn to the kid with the Facebook page, okay? We know that he's changed up the photo a little bit, but really, just cropping it isn't very transformative. Just cropping it isn't adding very, very much original creative content at all. The question is, has his use really undermined the market for yours? Is his use serving as a substitute for your original? Think about, as the creator of the photo, the owner of the right, what facts you would most want to show to make the best copyright case for yourself. And the best fact that you could show, is that there's a market for Facebook photos. There's a market for thumbnail images that people would be willing to pay money for what this kid took for free. And if the answer is yes, if the answer is that his use is a substitute for paying for something that there's a market for, it's probably not a fair use. That wraps up our discussion of copyright. And just for emphasis, please remember that giving credit to the creator is not a substitute for consent. It doesn't immunize you against a claim of copyright infringement. And remember this too. If you have to have an image, if you have to have a drawing, if you have to have a cartoon, there's never any substitute for doing it yourself.